like that. And hopefully, I'll be able to at least create some controversy by suggesting that regardless of their form, regardless of their level of sophistication, all of these universalist theories fall on the basis of the three objections that I've identified. So, and hopefully at the end I'll have something positive to say about what we ought to do instead of adopting the universalist approach. So what do I mean by a universalist theory? Let me give you one example, the first example. It's one that I call common law universalism. This is a theory that says that legal systems that are based on the common law approach, so the sort of judge-made law tracing its heritage back to the English legal system, those are inherently superior to systems that trace their origins back to the civil law, and in particular, the French civil law. Right? So it's a very general claim. Right? It's actually based largely on the work of a very prominent group of economists at a number of Ivy League schools who have written a very influential, widely cited set of papers that they summarized in a recent survey article this way, right? Based on roughly 10 years of research, using all sorts of cross-country statistical analyses, they concluded that countries with the common law systems have much better levels of investor protection, right? Levels of financial development, access to finance, ownership with dispersion, less government regulation, right? Less corruption, better functioning labor markets, better judicial systems, etc. Right? So it's a whole gamut of claims. But the bottom line is common law good, civil law bad. Right? Obviously, the French government takes issue with this. That, I think, is as clear an example of the kind of universalist claim that I'm talking about. And it's, you know, this is, again, influential. I guess you'll have to take my word for it. So, why do I think this is problematic? First of all, the normative argument, the claim that it ignores potential disagreements about what's important in life and about the ends that one ought to be trying to achieve with the legal system. Basically, some people might care about investor protection or having deep capital markets or less government regulation, right, or less corruption, but other people might disagree about the value of those things. Right? Now, of course, you might say that those are all means to achieving the more fundamental end of economic growth, right? But one thing that's interesting is that these authors were unable to demonstrate a connection between a common law origin and economic development. So they could demonstrate these intermediate connections to their satisfaction, but you know, they sort of apologized for this, but they just couldn't quite get the evidence to show that there is a connection between the legal origin and economic development. So you can't use that argument. You have to, if you want to adopt this theory as a theory of what you ought to do with your legal system, how you ought to design a legal system, you have to care about these objectives, right? And if you don't, then the theory presumably would fall, at least as a normative theory of how you ought to go about designing a legal system. So that's one way of saying that any universalist claim of this sort is vulnerable to the objection to these sort of philosophical objections. There's a different way in which people might disagree with this kind of theory and have a normative disagreement, which is to say, well, regardless of the ends, even if it did promote economic growth, even if this kind of system was good for the economy, we may still want to reject it just because we think there's something intrinsically good about a legal system that looks very different from the common law. We may like to have our legislature make laws as opposed to having the judge make laws. And that's just an end in of itself, something that we value. It's a principle we're committed to. Right? And again, the French might take that view. Now, I don't want to dwell on that, whether the French would, very many people in France would adhere to that, because I don't know that much about France. And some people might object to this claim and say, well, you know, only political philosophers or maybe some legal academics would care about the aesthetic value of the legal system and the values that are implicit in the way that, you know, these legal systems are designed. And what most people care about is, you know, peace and prosperity and economic growth, and these sorts of abstract ideals are much less relevant. I'm not sure that's right. So if you'll indulge me, let me just talk briefly about an example that I know a little more about than I know about France, which is a legal reform issue that has arisen recently in the English-speaking Caribbean, right? A sort of the hottest issue there in the past decade. Now, the countries in the English-speaking Caribbean are typically former British colonies, right? And during the colonial era, appeals from the courts in the Caribbean went up to the Judicial Committee of the Privy Council, which is a body that's basically the House of Lords, which is the highest court in the English legal system. Basically the House of Lords wearing a bunch of different hats. So same judges, but acting in a different capacity. So in the colonial era, appeals went up to the Privy Council. Most of the Caribbean countries have achieved their independence. They became independent in the 1960s or so. But they've mostly retained the system of using the Privy Council as the court of last resort, right? So appeals from the highest court in Jamaica go up to the Privy Council next. The Jamaican Supreme Court is not the last word. Right? Recently, though, there's been a move to abolish appeals to the Privy Council and instead have them go to either Supreme Courts in each island or to a body called the Caribbean Court of Justice. Now this, at first glance, is a little odd, right? Because the Privy Council is a tremendously respected institution. It's sort of one of the premier legal or judicial institutions in the world, certainly the font of the common law. So if you take this common law theory seriously, it's, what better way to get a common law system and ensure you've got a common law system than by ensuring that you've got guidance from the Privy Council, the sort of the original source of the common law. And also, the Privy Council is cheap, right? It's cheap for the Caribbean because the operating costs are borne by the UK government. So there are all sorts of pragmatic arguments that weigh in favor of retaining appeals to the Privy Council. But as far as I can tell, the main arguments that have been pulling in the opposite direction, right, in favor of a local alternative, the Caribbean Court of Justice or some sort of local Supreme Court, is an emotional one. Right? It's this idea that it's important to have our own courts. Right? And actually, the idea was summarized by a lawyer in the Caribbean saying self-government is better than good government. That's a pretty paradoxical statement, right? And I won't leave it to the philosophers to try to figure out whether there's any way to make sense of it. But it does suggest that this is a different set of values, right? It's not just valuing the purely economic outcomes or legal certainty or anything like that. It's about more than the economics. It's about nationalism, self-respect, right? National pride. And those values matter too. And to come back to the main point, it seems to me that values, people are going to disagree about what counts, what matters in designing a legal system. And I think that kind of attitude is going to prevent anyone from arguing that one size is going to fit all, is going to satisfy everyone around the world, regardless of the context. I can make the other 2 points in relation to the common law theory much more quickly. I'd said that there is also a concern that one size may not work for everything or in every situation because there might be substitutes for any given legal reform, right? So in the case of the common law, obviously countries like France and Belgium are doing just fine, thank you. They're pretty nice places to live. And they've presumably found substitutes for a common law system as a means of ensuring their economic development, right? As far as complements are concerned, well, the point is that a common law system requires judges. It involves judge-made law. And if you don't have well-trained judges who are trustworthy, right, and who can understand sophisticated disputes, then you may be better off with some other system, right, like having the legislature or administrative agencies run things. So without the complement of a good judiciary, again, I'm skeptical as to whether the common law would be the appropriate solution in every context. Okay, that was the first theory, which I think of as a relatively crude theory. It's sort of a sitting duck, as it were. It's an easy target. The next story is a little more, the next theory is a bit more sophisticated. But it's very explicit. One size fits all. Where did this quote come from? It comes from a World Bank document that was produced by as part of a project called the Doing Business Project.